Welcome. Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. I'm a professor at Mississippi College School of Law, but I tell you that only for identification purposes. Our views and interpretations of court rulings that I give are my own and should not be ascribed to my school or to my students. Now today, this evening, I want to talk with you about an issue in civil rights lawsuits that is very much front and center in the news today and now. I gave it a title of What, Then, and Now? Qualified immunity from civil rights lawsuits. I've been spending most of the day, it is late in the evening as I record this, trying to ponder how to talk with you about this topic. Qualified immunity, you're going to see it in the news a lot in 2020 as cases involving governmental officials, police officers, and others, actions being brought by individuals alleging deprivations of their constitutional rights. To introduce you to this topic, I decided that a good way to approach it would be by telling you three little stories. The first story, more general in nature, and the next two more specific in nature. And that would give you an introduction to the problem involved in evaluating qualified immunity, especially given the interpretation the US Supreme Court has given to this concept, to this defense. So let's start by going back 100 years. Look, even before I was born. So 100 years ago, slavery had ended. And some members of Congress, they looked around and they said that, well, they could see that many of the former slaves were still being denied equality and justice. In addition, there was this group called the KKK that sometimes with direct or maybe subtle government or state support, they also were depriving individuals of their liberties and terrorizing many Blacks especially in the Deep South, but also in other places. So Congress passed a law. Congress passed a law that provided that every person acting under color of law who deprived another of their constitutional rights shall be liable. And we know that law today as Section 1983. Excuse me. So the law, Section 1983, is designed to do two things. It's designed to compensate individuals with tort damages who have been deprived of their constitutional rights, but it's also designed to deter governmental officials. If they're going to be hauled into court, if there are damages to be paid, then hopefully that would deter, minimize, eliminate state official misconduct. Well, sadly, it did not come out that way. Systems of terror and justice continued against Blacks and against other individuals. Sometimes when the trials were held, the trial involving the official misconduct against, say, a Black individual, all of the Black jurors would be struck from the jury. It wasn't helped as the Supreme Court started to interpret this concept of qualified immunity. See, qualified immunity is meant to give officers some leeway. It's meant with the idea that we all make some mistakes, and for every mistake, an officer should not end up in a lengthy trial. But the way it's been interpreted, however, and we're going to talk about this more on the next tape, it has created a lot of problems for individuals when subjected to deprivations. So it has not really deterred official misconduct the way it may have initially been conceived. Let me give you the second story. This story is from 1970. I was in junior high school. Well, I guess they call it middle school now, in 1970. Now, in 1970, many times when people think about 1970, they think, oh, those were times of a lot of fun, of liberation. Brown versus Board of Education had been decided in 1954, but not so. Brown versus Board of Education was decided in 1954, but let me tell you, as to myself, even though I was born after 1954, I did not attend my first integrated class as a student until 1970, 71. A lot was going on in 1970. Young people were protesting. There was a mandatory military draft to send individuals to fight in Vietnam. A lot of people were opposed to that war. You may be surprised. You probably will not hear this speech on Martin Luther King, Dr. Martin Luther King's birthday, but Dr. King wrote a speech, delivered a speech called A Time to Break Silence, where he too gave a vocal and very passionate opposition to the Vietnam War. So you had protests going on, protests about racism, protests about the war, protests about sexism, protests about classism. And a lot of these protests were happening on college campuses as students were seeking more justice. Now imagine that there are two college campuses. On both of these campuses, there are student protests that are going on. On both of these campuses, the students are protesting the war, they're protesting racism, sexism, classism, all of these things. On both of these campuses, these protests have been going on for several days, and things are beginning to disperse. On both of these campuses, the students are sort of being pushed into this narrow area. On one campus, a field, on the other campus, along sort of a narrow street or alleyway near a girls' dormitory. In both of these cases, some police officers alleged that they thought they saw a sniper, but they never looked for a sniper. In both of these cases, the officers opened fire on the students without an official order being given to open fire. As a matter of fact, the commander said they didn't know where the fire was coming from, they didn't know who was shooting, and it took them a while to stop the officers who did fire from shooting. In one of the campuses, the officers not only opened fire toward where they said the sniper was, they said it was in the girls' dormitory. They fired all around and behind themselves. In both of these cases, students, college and high school students, were injured and killed. All was so similar. They both occurred in May 1970. So with everything being so similar, you would think that the results in the 1983 cases would also be similar. In one case, the families of the students who were killed received a financial settlement and a recovery. In the other case, they did not. In one of the cases, the incident received a lot of national attention and sympathy. In the other case, it did not. In one of the cases, many law school textbooks and civil rights discuss the resulting cases and is very prominent in the case book. In the other one, it is not. In one of the cases, the Supreme Court granted cert and carefully considered the Section 1983 issues. In the other case, the Supreme Court denied cert, and the lower court's opinion said it was going to only look at state law, not examine really anything about 1983, because it said state law here would tell the story, not the federal law. So why the different results? In class, my students, we've already examined these cases. They said they came up with a number of different reasons, maybe procedural posture or whatever, but the differences just seem to be so glaring. So I'm going to tell you that one of these cases involved Kent State in Ohio. Kent State University is predominantly white. The other case involved Jackson State University, a historically Black college and university in Mississippi. Now, in which case do you guess received the attention, eventually received some type of financial settlement? And in which case do you think the families did not receive anything? If you guess that the Jackson State case, there was no recovery for the families of those who were killed or injured, you guessed correctly. But then I want to know, why did you guess that? Why did you guess that the historically Black school would be the one with a different result? Let's go to the third story. The third story is a more recent case. In that case, in around 2013, a Black man was driving through Mississippi in his 2001 Mercedes convertible. He was following the law. He did not have any charges or anything against him. He was stopped by a police officer. The police officer, a white police officer, questioned him, held him on the road for 2 hours, kept insisting that he should do a search of the vehicle, brought out one of the dogs to see if the dog could sniff out drugs. There were no drugs. The officer misled the man, and eventually the man consented to a search of his vehicle. The officer caused great damage to his vehicle and then left him on the road. Now, this case is a recent case. There's an opinion you just have to read. And if you don't read the whole opinion all at once, you definitely should read the first 5 pages. The opinion is receiving a lot of national attention. It's written by Judge Carlton W. Reeves, an Obama appointee on a federal judge here in Mississippi. And the case, I've given you the name in the text down below the footnotes. But in this opinion that he writes, it is just very eloquently written. But he comes to the conclusion, he says the very unfortunate conclusion, that the way the US Supreme Court has structured qualified immunity for executive officials, including police officers, he has no alternative but to rule in favor of the police officer. He issues a challenge in his opinion, though, that the United States Supreme Court need to rethink qualified immunity, need to restructure or eliminate qualified immunity so we can get back to Section 1983. Section 1983 stating any person acting under color of law, depriving another of a constitutional right shall be liable. I want you to consider these stories for yourselves, and you will see kind of why I gave this clip the title I did. I said, what? Then is now? You know, we're seeking a taste of justice. We're seeking to learn. We're seeking to learn more about the Constitution. I believe that the more we learn, the more we will discuss, the more we will debate. And I do hope we move closer to the promises in the preamble. And the preamble of our Constitution says, we the people of the United States in order to establish justice. Now, in the next clip, I'm going to talk to you a little bit more about qualified immunity, some of the principles of qualified immunity that seem to still be so troubling and that in some ways continue to effectuate society the way it was 10 years ago, 50 years ago, and, well, we hope not 100 years ago, don't we? You take care.